Hi, my name is Lizzie Chan, and I'm a member of the CPR's Y-ADR Steering Committee. I'm delighted to host today's episode of the Corporate Counsel interview series. The Y-ADR seeks to educate the next generation of leaders in the ADR field about the full spectrum of dispute resolution and prevention mechanisms, and to provide an insider's view into how CPR's community of in-house counsel, external counsel, and experts in the ADR field are using these mechanisms to manage conflicts to enable purpose. And as part of this goal, I've created this interview series talking to in-house counsel from companies all around the world about their experiences with ADR and to share their advice on career progression and development for young practitioners in the ADR field. Today, I am delighted to welcome Alison Pearsall, who is Senior Legal Counsel at Veolia based in Paris. Hi, Alison. We're delighted to have you here today.
Thank you for inviting me.
My first question for you is, can you tell us a bit about your career experience and how you came to join Veolia?
Sure. Thanks again for having me here. And I'm grateful for this opportunity to talk to the young practitioners about a number of different topics. So to give you an idea of how I started out, I went to school in New York City and I finished a dual degree in law and energy policy. And after that, I started working directly in New York City for a full service Wall Street firm doing litigation. After a number of years, I moved to Paris to do arbitration, to join the arbitration team at what is now Denton's in Paris. And met a number of great colleagues there. So I did the jump across the pond. And after a number of years at Denton's, I decided to join the ICC Secretariat as the common law counsel. So we were overseeing about 100 arbitrations at a time and a team of about 6, I think, at the time. And that was really a great experience. As some people say, the ICC is a great school for arbitration because you get to see a large volume of arbitrations. You get to see how the arbitrators work. You get to read and scrutinize their awards. And you also get to work with counsel. And all of that is very useful later on in a career in arbitration. After my time at the ICC, I joined the in-house team at Shell when Peter Rees, Peter Rees, who was one of the arbitrators I had in some of my arbitrations at the ICC, decided to join Shell as the legal director, the general counsel for the entire group. And his idea was to set up essentially an in-house litigation team made up of mostly people who had been working in law firms and obviously others to form kind of a little law firm inside the company, shall we say. So that was a very exciting time because I was beginning a team from basically scratch to set up the structure of the team and how it would work, how people would evaluate risk, regardless of where they were sitting in the world, whether they were in Latin America or Europe or East Asia. And so I spent some time at Shell working in that litigation group and getting that up and running. And then most recently, I left Shell to join the in-house team at Veolia, which was also just starting up in its first couple of years of formation, shall we say, doing very similar work. So growing a team dedicated to disputes in-house.
You have had such a rich experience in ADR, both in the institutional context and at Shell, and you've really pioneered a lot of ADR in the companies and the organizations that you've worked in. I'd like to focus a little on your current role at Veolia and ask you, how is the legal function there organized? What is your role and what are the types of disputes that you're involved in?
So I work for the head office of Veolia. So I think it's important when you're talking about a disputes team to know whether or not you're working in a local operating company or in the sort of the overarching, the mothership, so to speak. So I work for the head office. And we are about 4 people, and we divided the world sort of regionally amongst us. So I'm responsible for litigation and arbitration in North America, Northern Europe, UK, Ireland, and Australia. And so within those regional responsibilities, I'm responsible for litigation that's over a certain amount, so large or especially complex or risky litigation that gets reported up to us. I'm responsible for managing that litigation, and in certain cases, handling it directly, depending on what the risks are or what the subject matter is.
You mentioned a bit earlier about Peter Rees setting up effectively an in-house law firm within Shell. And that's really interesting because I think that the role of the in-house counsel has evolved over time. So do you have any additional insights that you can share on the role of in-house counsel, especially in a global company?
Well, I think you're right. I think it is evolving. And I think more and more companies that are subject to a lot of litigation have found that it's quite interesting on a number of fronts to have a dedicated team instead of outsourcing that work, because there are a number of things that can be done by in-house. So I think in terms of insights, I would say one of the concerns that I often hear from outside counsel is, oh, well, if there's a dedicated internal disputes team, you won't need external counsel anymore. And of course, that's not true. I think in large litigations and large arbitrations, we will always be using external counsel because of just the number of hands on deck that you need for a very complex matter is not, is such that you can't necessarily just handle it in-house. There are smaller matters, though, however, that you could. While I was at Shell, I was able to do some arbitrations without outside counsel because they were small, they were an issue of black letter law, there was not too much document production, that type of thing. And I think that makes the opportunity to do some things like that also make the position quite attractive, I think, to people who have had an experience working in a law firm, that you're not necessarily just, going in-house and you're not becoming just a project manager, but that you can still have some hands-on experience. On the other hand, I think, another aspect that makes it quite interesting to go in-house when you have been in a law firm is that you bring that experience of having been in a law firm, both worlds. And I think that allows better communication, not only between the external counsel and the client, shall we say, because you have somebody in the client who understands how external counsel works, but on the other, vice versa also, you can, explain to those who have just been in-house sort of how things work with external counsel and make that communication more fluid.
I really like the theme of collaboration that you touched on between in-house counsel and external counsel, and also your comments about the perspectives and experience that you bring from having been in private practice to the in-house role. And actually, I think you might have wanted
I think they're complementary. I think they're complementary, just to add to what you're saying. I don't think it's an either or kind of, we're not there to replace external counsel, but I think that if the collaboration between the two can be really productive if each person understands, the in-house counsel and the external counsel understand that they fulfill different roles in an arbitration, but that they're complementary. And if they work together, you make a very strong team.
Absolutely. And that's a really interesting point, because the recently elected president of the ICC Court of Arbitration, Claudia Salomon, has talked about wanting to involve in-house counsel more in the arbitration process. So she suggested that tribunals should actively encourage in-house counsel to be part of CMCs and communications with the tribunal. So I think you're absolutely right that in-house counsel and external counsel role are collaborative and complementary. And of course, that's an important part of why CPR exists. So I found out the other week that I think back in 1977, the CPR was created by collaboration of internal counsel and external counsel with a view of lowering the costs of litigation. And of course, the CPR's work is much broader than that now. And one of the CPR's core focuses continues to be on dispute prevention and avoiding conflict. And I was wondering if you have any insights on best practices for achieving those goals.
Sure. And first of all, I would say I'm a big proponent of mediation as a way of resolving disputes in a business context, because as we are always reminded, we are not, as a company, in the business of litigation. We're in the business of, making deals and making business go forward. And in order for that to happen, relationships need to be preserved. And one of the big advantages to mediating a dispute is that oftentimes you're able to preserve that relationship with the client or whoever it might be, the business partner that will be very valuable to you later. So in that aspect, I think one of the things that I found quite helpful in terms of promoting mediation while I was at Shell, for example, that company decided to be part of the CPR pledge, which essentially says that the company pledges to resolve their disputes through mediation as a first attempt where it's appropriate. And I think that is quite helpful on a practical level for an in-house counsel, because that means that you don't need to necessarily include a mediation clause in your contracts. Or, if you have a tiered clause, you don't have to have a mediation aspect to that. It's something that is available to you to propose to your counterparty when a dispute arises, because it's a matter of company policy, not because it's in the contract or not because you, as some business people think, you have a weak case and so you want to mediate. It's not that at all. You can say in a completely neutral context, we have a policy of mediating as a first step. So we propose to do that here. So I think that's a very practical way to go about it, to have a company policy. Not all companies have that, but I think it goes hand in hand. Where you have a company, if you're in a company that doesn't have a policy like that, there's the role of in-house counsel to educate your business partners in-house to what mediation is, how it's different from arbitration, which may sound obvious, but it's not always the case that everybody knows the difference, and to bring forward the strong points of mediation. And personally speaking, the way I've done this is the way I've encouraged my business partners to mediate is to tell them, look, this is essentially the last opportunity you have to control the process, is mediation. Because in mediation, you sit at the table, you're the one who's doing the talking, you have your partner who you know better than I do, with whom you have a dispute, sitting across from you at the table, and you can talk to each other directly without the lawyers getting involved. But if this goes to arbitration, you'll lose that control. And the lawyers will be the ones who will be taking over the legal process, and the decision will be made by 3 arbitrators who you don't know. So if you want to avoid that, at least give mediation a shot. And there are a lot of ways to give mediation a chance without losing time, by even having a day mediation or 2-day mediation. And sometimes that's all it takes to convince the business that maybe there's a possibility of resolution that way.
I really appreciated your insights there, one of which is the power of default policies. I remember reading a book called Nudge a long time ago, and even, putting certain products at eye level makes it, more likely that consumers will buy that particular product. So in the same way, having a policy of using mediation might encourage its use more frequently. I also really appreciated what you said about control. And actually, that's a really great way to encourage companies to engage in mediation, because they do continue to have control over the process, whereas they wouldn't get that in arbitration. This leads quite nicely to my next question, which is about early case assessment. And you've already talked about earlier how, depending on the particular risks of a case, you might handle that case in-house, or you might take it to external counsel. And you might consider whether a particular conflict is suitable for resolution by mediation or by some other method. I was wondering if you could share any general insights on best practices for early case assessment.
Oh, that's a good question, and it's something that I'm working on actually. I think it's helpful to have, especially if you have a global group, to have a process for early case assessment that is somewhat standardized, and so that people go through the same steps and have the same evaluation of risk, in order to get some kind of homogeneity, shall we say, out of it. So I think there are a number of steps, I think, to this. initially, I think, I think the first element of a case assessment is to do obviously a deep dive into the facts and the documents, and make sure that you have all the documents. I think that's a process that people don't see normally because it happens in-house at the beginning of a dispute. I think your role as an in-house counsel there is also to think critically about the information that you receive, and think, am I missing anything? Is this only one side of the story? What else do I need to know? And to get and to obtain and preserve as many of the necessary documents as you can. I think at that point you can, after you've done an initial deep dive and a risk assessment, you have a sense of whether or not you want to hire external counsel. And I think that's also just to go back to the dispute resolution theme in a sense. You have to talk to the business and understand what is their goal here. So they'll usually come to you and they're very upset because something's gone wrong and they think it's the fault of the other guy. And they immediately want to, they saw they have a dispute resolution clause that says something about arbitration, and they immediately want to arbitrate because that's what it says. And, they want to do that and get on with their lives. And sometimes if you talk to them, if you do a deep dive into the case with them and you get the documents and you start to talk to them, you'll get an idea of actually, is this something that they really want to fight all the way to the end and get a damages award? Or is this something that, they're quite upset about the way it was handled, but, they probably don't want to take an arbitration all the way to the end. They probably want to settle somewhere. Or is this something that can be resolved by, maybe a meet and confer type situation? So in the situation in which I would say is probably most common, the business would probably be happy with a settlement, and the settlement sort of sooner rather than later, given that later will run up more litigation costs. This is something that you can fold into your request for proposal. For example, when you're looking for external counsel, you can incentivize external counsel to have the same incentives as you do in terms of settlement. And so you ask them for a proposal, or in the case that I would ask them for a proposal of how they would represent us in this case, and what they would do to help us settle at different points, the different appropriate points in the arbitration. And you can build in an uplift if a settlement is achieved within that time frame. So obviously the sooner, the bigger the uplift. And I think that's one way to make sure that in-house counsel and external counsel are both rowing in the same direction. And you don't have one who wants to settle and the other one who wants to go to arbitration.
I think that's a really thoughtful way to encourage external counsel to mediate, because you use different incentives, and here it would be like the cost incentive to try to think about a settlement at different junctures of a dispute. Something else I wanted to pick up on is your comment about speaking with your commercial counterparts and understanding their goals. So, you have the opportunity as in-house counsel to speak directly to the commercial function and have a perspective on the goals of the company in a way that external counsel don't. So what's your suggestion for external counsel for better understanding the client's priorities?
That's key, I think. It's easier for in-house counsel to understand what the priorities are because you have direct access to the business. And I think to start there, in order to be able to get that information and to become a trusted partner, you have to understand the business. You have to understand how they make money. You have to understand what their risks are. You have to understand, what keeps them up at night. And that's something that, as a first step, the in-house counsel has to understand well and prove that they can speak the same language as their business counterpart, in order for the business counterpart to see the in-house counsel not as somebody who's blocking the way or there to say no or et cetera, but as somebody who's really in there with them as a partner trying to get done what they're trying to get done, within the law, so to speak. I think as external counsel, you can, if you know the sector, that's really helpful because that will give you a lot of insights into sort of what the priorities are for this particular business, and then building a relationship. So I think, obviously and working repeatedly with the same client is ideal, because you get to know the client better, you get to know the people involved, the personalities, and the goals and the priorities of that company. The hardest one is obviously when you're working for a client for the first time, and I think in that sense, the partnership between in-house and external counsel is key, because the in-house counsel is the gatekeeper essentially to the business, and they are the ones who can give external counsel the information they need in order that they understand the business better.
I really love your comment about external counsel, being there with the in-house counsel and others in the company and really doing this together.
Yeah.
I wanted to pick up on your comment earlier about the use of mediation early in the disputes process and broaden that topic a little bit. Can you talk about like different ADR tools that you've used and which you think are particularly amenable for certain types of disputes?
It's a broad question. I can give you an example of from my experience in terms of mediation. I think one of the challenges that I've run into in proposing mediation to the business is that usually your business counterpart is a professional negotiator. And so if they're coming to you with a problem they can't solve, they've tried everything. They've already negotiated everything. And they see mediation as just another form of negotiation. And so when you propose a mediator who they've never heard of before to do a mediation, which they don't really understand what that is, their first reflex usually is to say, well, what is this guy or this woman going to be able to accomplish that I haven't been? I do this for a living, and like this guy, I'm telling you, he's totally unreasonable. He's not going to listen to anything. Like, what's this mediator going to be able to accomplish that I can't? And I think, as you know very well, there's a lot to mediation, to a successful mediation that is behind the scenes in terms of understanding the psychology and the priorities and the non-spoken priorities and the underlying issues and the stuff that's not necessarily what the initial conflict appears to be. And I had one case in which that had been going on for years, and I had this sense that essentially, if the two main parties could sit down and talk to each other and look each other in the eye instead of throwing papers back and forth at each other, because it was very emotional, they would have to come to an agreement because they were both reasonable people and that it wasn't an insurmountable problem. But the egos had gotten so involved at this point that it was very difficult to get anybody to even liberate their schedules to do anything. And so I finally laid it out like this. I said, look, you're both sides are saying that, yes, they want to, of course they want to resolve this. They want to settle, but it's the other side that's being unreasonable. So I said, if you both want to settle, then I propose that you give me, I think I gave them 24 hours to try mediation. And if it doesn't work in 24 hours or you don't like it, or for whatever reason, it's not what you were looking for, that's fine. We can continue with the arbitration. But if you're too busy to give me 24 hours to try mediation, then you're not serious about trying to solve this. That's not true. And when I put it that way, I basically called their bluff, and they had to come to the table. And so they came to the table for, it was in terms of organization, was a big feat of organization, but we did finally get everybody around the table for a one-day mediation. And as I anticipated, it went well. It went well enough and made people curious enough that they added on another day and another day. So essentially the big hurdle was getting people to the table in the first place. And once they saw we were able to see the other person face to face, everybody was there. They saw that everybody cleared their schedules for this. I think it created an ambience in which discussion took place, which hadn't taken place in years, not at the same level. So I think that was one way that I resolved an impasse in convincing people in-house to try mediation.
I really love that example. Now I was wondering, do you use external counsel in your mediation dispute settlement process?
That's a good question. And I think that's something that comes up a lot. There's a big debate about the role of external counsel in mediation and how to deal with external counsel who see mediation as a distraction from the arbitration that they just want to continue. And I think there are 2 points that I make on that. The first is, I think As in-house counsel, I think now, I don't know if this was as much the case maybe 15 or 20 years ago, but many in-house counsel have worked in law firms. They've had long careers, sometimes even in law firms. They know, they know the world of mediation, they know the world of arbitration quite well, and they're fully capable of handling the mediation without external counsel. And that's sometimes preferable because the business knows, if you're talking to an in-house counsel, the business knows you well. They're happy to go to a mediation with you as opposed to an external counsel they're not really sure of and who might charge a lot of money. In the mediation, as I said, it's really, if it's done correctly, in my opinion, it's really run by the parties. So there are a number of documents and submissions that you need to make, like a position statement, et cetera. But that's something that an in-house counsel can draft by themselves, and that they draft with the help of their business partner. But again, in the mediation, it's the business partner who's going to be doing most of the talking, and the in-house counsel is there more in a support role. And that's almost preferable in a way, because you don't have to worry, or the business doesn't have to worry about lawyers interfering, because the outside counsel won't be there. And a second way to sort of address this, if you really do want to have external counsel involved, because everybody is comfortable with them, but you want to make sure that they give it their best and they don't just use it as a check the box exercise because they really want to make sure they get to an arbitration hearing, is, as I said before, you can incentivize them to say, look, our priority here is to settle this through mediation. So we would like you to represent us at the mediation. And if you can successfully, if we're able to find a solution through mediation, a successful solution, you provide an uplift for them that's important, I'd say, enough to incentivize them to really focus on the mediation and give it their all.
I can really see why mediation is a go-to dispute resolution mechanism for companies, for the very reason that you gave at the beginning, which is control over the process. I want to change tack a little and focus on an issue that is very important to both of us. So the audience might not know, but we're both board members of Arbitral Women, which is a non-governmental organization in the international arbitration and mediation field that serves to unite and promote women in our field. So I was wondering if you could share your insights on what you think about diversity and its importance in our field.
Well, clearly diversity is very important in the field of arbitration. There's still a lot of work to be done. I think we've accomplished quite a bit in the last few years. If you look at the percentage of women on arbitral tribunals, these statistics are often published by the LCIA and the ICC. But I think what you see, or at least what I see when I look at those statistics, what really stands out for me is that the percentage of party appointed arbitrators, percentage of women appointed by parties as arbitrators is lower than the institutions. And I think that's a statistic that really kind of sticks out as a sore point for me, because they're in the field of arbitration, the clients, the users, however you want to talk about them, the in-house counsel have a really privileged position in which they can, move the cursor, as you say in French, or increase the amount of diversity on arbitral tribunals, and also in the representation by external counsel, because they're the client. And I think too few in-house counsel really use that position to advance diversity. So one of the things that, there's Arbitral Women, obviously, that works very hard on promoting this. There's also the Pledge for Equal Representation Arbitration that has come out with corporate guidelines for in-house counsel and other practical advice on how you can encourage diversity in your representation and in your tribunals in arbitration. To give you some concrete examples of what I try to do that I think is something that's very productive and helpful, is that when you have an arbitration in-house and you're looking at arbitrators, that any list that comes to you include, at least 2 women. and if they're not two women, that you go back to whoever it is who gave you the list, if it's coming up through a team member or if it's coming up from a local in-house counsel, and you ask why there aren't any women on the list, and you propose some. So I think there are two aspects of that. One is you need to be ready to push back a bit on lists that don't include women or minorities, and secondly, I think you also have to be informed. And I think this is a point where in-house counsel can improve their roles, so to speak, their knowledge of the sector by informing themselves, by going to conferences, by meeting arbitrators, and by meeting external counsel more, so that they themselves have a repertoire in their own heads of who's in the sector that they would like to work with, so that they can propose them. And that makes them less dependent also on external counsel, who may give you a list of who they would like to appoint that may not be as diverse as you'd like. So diversity obviously is very important on tribunals and in external counsel representation, because it allows you to have different points of view at the table, and that will give you a better decision if you're appointing arbitrators, and it will probably give you a better result if you're appointing a diverse external counsel team.
I'm really inspired by all the work you do in advancing gender diversity and other forms of diversity in our field. And I agree with you that there are so many junctures in the dispute resolution process where we can do a little bit more to help to enable, more appointments of diverse candidates. So as you mentioned, external counsel producing diverse shortlists, and then also in-house counsel injecting new names into this list. And I agree with you. I think organizations like Arbitral Women and The Pledge and many others have really done a lot to raise the profile of women arbitrators. And I think actually one of the benefits of the pandemic is we're all on LinkedIn now. Mm-hmm. And I think that's been, more and more people use it. And I think that's been a really good way to grow our awareness of names that we might not otherwise have been aware of.
I think that internally, I think there's definitely a learning curve in some litigation departments to ensure that the in-house counsel increase their knowledge of the candidates that are out there. Also, so that you don't end up in a situation in which you want to appoint a certain person in Paris, say, to an arbitral tribunal, and then you find out that one of your subsidiaries has already appointed them twice in Latin America. So, there's a coordination internally where you have a disputes team to touch base with each other, so who's being appointed, why, and you don't always appoint the same people.
Absolutely, that's a really great point. And my last question for you is, what advice do you have for young practitioners who are looking for an in-house career?
That's a good question. So I think, the first piece of advice I would give is don't expect every company to have a dedicated disputes team. So as I said before, that companies are in the business of doing business, not doing litigation. And so you probably will only find a dedicated disputes team in sectors that tend to be, litigious, that tend to, I think of oil and gas or pharmaceuticals, for example. Those are two examples of where, of sectors in which there is a lot of litigation. So I think my advice would be have a look at those sectors that are heavily litigious, because that's where you'll find the opportunities, and ask yourself, do you want to work in that sector? Does pharmaceuticals really interest you, or are you passionate about energy and oil and gas? And what does that mean? And where is that sector going in the future? So I think just to be aware of that, it's harder to go in-house as a litigation specialist than it is as a corporate specialist. There are opportunities, but again, they're in certain sectors. And so you should be aware of that and in your choice of career, if that's where you want to work.
I'm really glad you raised that, because I think a lot of lawyers who are starting off in private practice might not know that there are not as many in-house pathways in the disputes field. And I also agree with you, it's so important to know the industry and also to know about the company. So one of the interviewees that I talked to about she was like, you know, it was really important to me when I was looking for an in-house role to find a company that created something that I was really excited about. And it was, you know, that the good or service of that company that she was so passionate about and wanted to be part of that company.
I think that's important because that's what you're going to be doing day in and day out. And it's you're a lot more excited about a job that's in a sector that you believe in or that you're excited about because it's going somewhere than one in which you hadn't really thought about it, but, you know, this is where you ended up. So if you want to make a career out of it, I think, you know, it takes some time to think about really, you know, what you're curious about, what you get excited about, and see what opportunities there are in that sector.
Absolutely. Well, thank you so much, Alison, for your time and for sharing these fantastic insights, which I know will be much appreciated by our audience. Thank you again.
It was a pleasure. Thank you very much for having me.